Happy New Year, and welcome back to The Legal Take, the law behind the headlines. I'm Andrea Holzer. We took a short break for the holidays, but today we're back with updates on one of the most contentious transparency battles in recent memory, the release of the Epstein files, the government's long-sealed investigative records related to Jeffrey Epstein and his associates. After years of secrecy, a new federal law compelled the Department of Justice to disclose these documents. But the story unfolding now raises questions about what's being released, what's still hidden, and why the public and lawmakers are pushing for even more transparency. We're going to break down the latest developments, the law that forced this disclosure, what the files actually contain so far, and the legal and political implications of all of this. Let's recap how we got here. The Epstein files story is rooted in a new law passed by a bipartisan majority in Congress, known as the Epstein Files Transparency Act. The law requires the Attorney General to publicly release all unclassified documents, communications, and investigative materials in the Department of Justice's possession connected to Jeffrey Epstein's investigations and prosecutions. That includes records related to the 2005 Florida and 2019 New York investigations, files about Epstein's associate, Ghislaine Maxwell, flight logs, communications, and internal DOJ memos, and names of individuals referenced in connection with Epstein's activities and investigations. Federal law allows redaction or withholding of personal data of victims and materials that could jeopardize ongoing investigations. But it explicitly disallows withholding due to embarrassment, reputational harm, or political sensitivity. The law gave the DOJ a 30-day deadline to December 19, 2025, to release these materials. But that deadline has been controversial and, as we'll see, difficult to meet. In mid-December 2025, the DOJ began releasing Epstein files in accordance with the Transparency Act. These were the first publicly accessible chunks of a massive trove of documents. In December, the Justice Department released thousands of photos, police reports, and other records from the Epstein files, some of which included previously unseen material. But many documents were heavily redacted. Since that initial tranche, the department has released more than 11,000 additional records, including references to high-profile individuals and internal government communications. The files are searchable via an online portal hosted by the DOJ called the Epstein Library, which continues to be updated as new material is processed. So what's in there? Court records and investigative files, flight logs and correspondence, photos and handwritten documents, and FBI and DOJ reports. Many of these shed light on the extent of Epstein's network and the government's investigations. But they also raise new questions about what was redacted and why. One of the most legally significant developments involves grand jury transcripts from both the 2005 Florida investigation and the 2019 federal sex trafficking case. Grand jury transcripts are traditionally among the most protected categories of documents in the U.S. legal system. In recent weeks, a federal judge granted the Justice Department's request to unseal grand jury transcripts that were part of the early Epstein investigations. This marked a major shift because grand jury secrecy has long been one of the most sacrosanct legal protections. Similar orders have been issued in related cases involving Ghislaine Maxwell, setting the stage for broader public access to what was once sealed testimony. Despite these rulings, concerns remain about the extent of redactions and how much meaningful information is actually being disclosed. Even with these releases, the story isn't over, not by a long shot. Just as December's deadline passed, reporters revealed that the Justice Department still has millions of pages left to review and redact, pushing expected release dates well into January of 2026. According to the latest reporting, the DOJ is now reviewing over 5.2 million pages of documents, photos, videos, audio files, and internal communications related to Epstein and Maxwell, far more than originally anticipated, which has slowed the pace of full disclosure. The department says it's committing hundreds of attorneys and analysts to review the process, and that victim privacy and redactions are key priorities. But the delay has drawn bipartisan criticism in Congress, with some lawmakers demanding accountability and full compliance with the Transparency Act. There's also a political dimension. Some released files include mention of prominent public figures, prompting debate about how and whether those references should be disclosed or interpreted. One of the biggest misconceptions about the Epstein files is that they're going to contain a single explosive revelation, a smoking gun that suddenly explains everything. That's not what these documents are doing. Instead, what we're seeing is a clearer picture of how Epstein operated, how investigators tracked him, and where the system failed, repeatedly. Let's walk through what the released materials actually show so far. First up, Epstein's network was known, even if it was poorly acted on. One of the most consistent themes across the released files is this: law enforcement knew Epstein was surrounded by powerful, well-connected people. The documents include contact lists and correspondence showing Epstein's access to wealthy individuals, politicians, academics, and business leaders. Internal law enforcement notes referencing his social circles, and flight records and travel documentation that investigators were aware of years before his 2019 arrest. What's important here is not speculation about guilt, but institutional awareness. These files suggest Epstein's network was not a mystery to investigators. The issue was that what authorities chose to do with that information, and how cautiously or aggressively they pursued leads involving influential names. Number 2 is that investigators identified patterns, not isolated incidents. Another key takeaway is that Epstein's conduct was never viewed as a one-off. The files show repeated references to patterns of recruitment, abuse, and payment, consistent descriptions of how victims were approached, and notes indicating that investigators believed Epstein's operation was structured and ongoing. This matters legally because it undercuts the idea that Epstein's crimes were misunderstood or minimized early on. Instead, the documents reflect an understanding of systemic behavior without corresponding systemic enforcement. Number 3 is the role of associates is more explicit than before. While the files do not conclusively resolve who knew what or when, they do reveal how frequently Epstein was described as operating with assistants. These documents reference coordinated travel, third parties arranging meetings or logistics, and individuals acting as intermediaries or facilitators. Again, these references are not final legal conclusions, but they show investigators were looking beyond Epstein as a lone actor. This is especially relevant in light of Ghislaine Maxwell's conviction, which legally confirms that Epstein did not act alone. Number 4 is missed opportunities and institutional hesitation are documented. Perhaps the most troubling revelation is not about Epstein himself, but about the system around him. The files reveal leads were identified but not fully pursued, jurisdictional confusion between state and federal authorities, delays in follow-up despite credible information, and internal discussions showing uncertainty about how aggressively to proceed. From a legal perspective, this raises serious questions about prosecutorial discretion, resource allocation, and whether Epstein benefited from informal protection, even without explicit favoritism. Number 5 is what the files do not do and why that matters. It's equally important to be clear about what these documents do not establish. They do not prove criminal conduct by every named individual, replace the need for due process, or automatically translate into new prosecutions. Many names appear because they were witnesses, contacts, referenced in communications, and mentioned without allegation. This distinction matters, especially in a moment when public speculation can move faster than legal conclusions. And number 6 is why these findings still matter, even without new charges. So if these documents don't immediately lead to indictments, why are they important? They're important because they show how power and proximity can complicate criminal investigations, reveal how systems fall victim over time, create a public record that can't easily be buried again, and force institutions to explain past decisions under scrutiny. From a legal standpoint, transparency itself is a form of accountability, even when it's uncomfortable. What the Epstein files ultimately reveal isn't just the story of one man. It's a case study in how the justice system handles, or struggles to handle, crimes involving wealth, influence, and secrecy. And that leads directly to the next question. What does this all mean legally? And what happens next? This episode isn't just about sensational photos, or who appears in them. It's about the limits of federal secrecy law, grand jury protections, and transparency in high-profile investigations. So why does this matter legally? First is grand jury secrecy versus public accountability. Traditionally, grand jury proceedings are sealed in order to protect witness confidentiality, preserve the integrity of ongoing investigations, and encourage candid testimony. But under the Epstein Files Transparency Act, discretion has shifted. Courts have now ruled that in this unique context, the statutory requirement to release files overrides long-standing secrecy norms, at least for unclassified material. That raises questions about how far congressional transparency mandates can alter procedural protections that were once nearly absolute. Next is victim privacy versus public interest. Redactions are meant to protect victims, but the debate now centers on whether the redactions are overly broad, whether the DOJ is complying in good faith, and whether politically sensitive information should be disclosed. This is a legal and ethical dilemma, striking a balance between privacy interests and the public's right to know. Third is political backlash and legislative pressure. Even bipartisan supporters of the Transparency Act are now pushing for more aggressive enforcement, oversight, and even contempt actions against DOJ leadership for missing deadlines. This is unusual in American politics, something that underscores how emotionally and politically charged the Epstein file saga remains. Here are the key developments to follow. Rolling document releases. The DOJ continues to release new material as it's reviewed. Congressional oversight. Lawmakers may pursue enforcement hearings or sanctions. Public scrutiny. Journalists and advocates are combing through released files for meaningful evidence. Legal challenges to redaction decisions. Expect litigation over how and why material is withheld. And political fallout. Reactions to names and associations revealed could ripple into broader discourse. This isn't a one-episode story. It's shaping up to be a multi-season legal saga. This episode of The Legal Take covered a complex and evolving story. A rare moment when congressional action forced the government to expose years' worth of investigative material about one of the most notorious criminals in recent history. What's already been released is just the beginning. The legal, ethical, and political questions raised by these files will be debated for years to come. If you found this breakout helpful, hit subscribe, leave your questions or thoughts below, and click the bell so you don't miss our next update. I'm Andrea Holzer, and this has been The Legal Take. Until next time, stay informed, stay curious, and stay legally minded.